Hello, everybody. Welcome to another of our G-IPTech lectures. So very nice to see almost a full room. Of course, I'm sure as thanks to the great speaker that we have today. So I'm very, very happy that Professor Séverine Dusollier accepted our invitation. I mean, you all know that she's one of the leading figures in IP in Europe and especially in copyright law. Just to give you a little bit of information about Professor Dusollier, she's Professor of Intellectual Property at Sciences Po in Paris. She also holds a senior chair at the Institut Universitaire de France. I hope my pronunciation is still good. I spent a few years in Strasbourg. That's all I got, a little bit of pronunciation, but my French is awful. And she's also the Vice Dean for Research of the Law School, member of its doctoral committee, and head of the Master in Innovation Law. She's also a qualified member of the French Copyright Council, and she's a founding member of the European Copyright Society, to which she contributed very much and made it one of the important copyright institutions in Europe. Her current research interests are digital issues of copyright, the concept of authorship, contractual protection of authors and performers, and she's been working quite a lot on commons and inclusivity, which actually is a topic that for which we share quite a lot of interest, right? So today she's going to talk about a topic that we all want to hear about, which is on the headlines every single day, how artificial intelligence is going to disrupt the creative market and is going to disrupt our idea of authorship. So, Séverine, thank you very much again for being here, and the floor is yours. So now Séverine is going to deliver her presentation, and then we're going to have time for a Q&A, plenty of time. So just prepare your questions, and then we'll go ahead with that later. Thank you.
Thank you. Okay, so thank you very much, and let me reciprocate my thanks to Giancarlo for this nice introduction and to Pratt for inviting me here. It's my first time in Ireland, and I'm really happy to be here with you and to talk about this legal aesthetics of AI. Actually, this presentation is part of a work in progress and of a paper that I'm currently writing with a friend who is also an artist, a digital activist, a cultural studies scholar, and a computer science person. And so I'm learning a lot from him. And in that article, we really want to look at how the generation of images by AI and machine learning disrupt the modes of perception of images in different disciplines, so in law, but also in aesthetics, in art history, and critique, and in computer science. So what I will present to you today is my part of the job, or at least it is the legal dimension of that question of aesthetics. So by aesthetics, I mean the judgment of art, the judgment of beauty. And by legal aesthetic is really how the question I want to put forward is how law perceives the images and works that are produced by generative AI, and with which legal categories the law, and by law I mean also legal professions, so the judges, the lawyers, how they are appreciating the works that are produced, and how law, by mobilizing its specific legal structure, legal categories, techniques and concepts, is making works. So I should say immediately that I'm not so much interested in the answers that courts will give to the questions that we hear all day, you know, like, is a work generated by AI protected by copyright? Does machine learning process copying works that are in the data set? And should authors of those input works should be compensated, etc.? I don't care that much. Of course I care, but not in the frame of that article. I don't think I'll have that presentation. The answers for me are not the things that interest me today. What interests me is rather how those questions are framed and what aesthetics and epistemology of copyright is mobilized and maybe reiterated. And so I will start with an illustration of what I mean by how law is making works and what it could mean literally. This is about an artistic project that was done by a friend, Cornelia Solfrank, who is a German artist and art theorist. And she made she actually programmed, she's also a hacker, and she programmed the net art generator already in 2004. So it's 20 years ago. So it was not really based on AI. It has an algorithmic basis, but not AI as we understand it today. And actually what it does was to propose to visitors of exhibition to just generate works of art based on the Warhol by the flowers by Warhol. And so the name of the project was called This Is Not By Me, because she's really challenging the notion of copy, of authorship, etc. And so she then transferred the project into NFTs and everything. So it's a long project that still continues today. And actually, you know, you could produce that. So she could produce that herself, or you could, as a visitor of an exhibition, just do some instructions with the computer, what we would call prompts today in AI parlance, and you would generate a new version of Warhol famous flowers. Of course, it's not the first time that the flowers by Warhol has been copied, and one of the greatest appropriationist artist, Hélène Sturtevant, made her own reproduction of Warhol flowers. The difference is that at the time, actually, Warhol lent her the plates he used to produce the flowers. So she had all the material to do faithful copies. And that was also considered as a work of art, whatever the authorship you could invest in that work by Hélène Sturtevant. But actually, what was interesting for me at the time, because I witnessed that story, but it's still with me today, is that at some point at the beginning of that artistic project in the early 2000 years, actually, she wanted, so Cornelia Solfrank wanted to make an exhibition out of the Warhol flowers and that process that she proposed to visitors of the exhibition. And actually the Museum of Basel, where she was supposed to exhibit, suddenly stopped the exhibition and said, no, we cannot do that. The legal team will never accept, and we cannot really, you know, run the risk of getting sued. And so she just transformed the project, and what she exhibited was that. So actually there were monitors with videos of lawyers speaking about her work and whether her work was actually valid or not, was it legitimate or not. And, you know, the exhibition was just how lawyers would actually validate a own creation. So it was a literal illustration of how law makes arts, you know. And I think that, and there was a conference, a debate to which I participated at the time, and this is how I met her. But I think this was really amazing how she was really putting literally in the exhibition the performance of lawyers discussing what art should be and what her creation could be. And so actually, this is how I will ask the question again, how the legal processes and the legal frame is actually saying what art can be or should be. And of course, all legal processes, even outside of copyright, they are processes that made fiction and they objectify things. They create legal concept and they create reality. So they are producing reality. You know, law is a production of reality. It's not reality. It's just another process. And copyright is no different, of course. And in copyright, works are made through the concept and the device of authorship. And this concept of authorship can be understood in different levels. The first and basic level is the way authorship is linked with the notion of originality and of the notion of author, who are both entangled and required for a creation to be copyrightable and considered as a work of authorship. So the originality, as most of you might know, is defined in the EU as the authors on intellectual creation. And the CGEU said that there should be an author who made creative choices that reflects in the work his or her personality for a work to be protected. So this is the legal rule. But actually, on a more epistemological level, the notion of authorship organizes and explains the copyright regime in a more profound way. There are indeed two key functions of this notion of authorship in copyright. The first is the authorship as a source of creation and the legal concept to which it links its originality. But actually, beyond the tool of originality, this notion of authorship as the source of creation really sees the author, the creator, as an individual and romantic genius who is creating ex nihilo, who is never fed with what precedes him or her, what is the cultural scene in which he or she evolves, but is creating ex nihilo, and it puts his or her personality into what it creates. And you can find this in the word original, he is at the origin of the work and at the sole origin of the work. But then authorship is also a source of control, and you can see that in the word authorization or authorizing, because the work as an author, that author is the legal subject. So he's not a real body, he's not a real person, he's a legal subject who is actually the source of control of what can be done with the creation. And he has the sole meaning of the work, and he has a control over copy. And by copy, I mean all that is done with a work, a reuse, a circulation, an adaptation, a derivative work, etc. So actually, authorship is also what creates that dividing line between the original work and the infringing copy or the pirate copy, when that is said sometimes. So through these two functions, actually, authorship makes creation into objects of property, based on luck and everything. So, because it is a figure of modernity, that legal subject is also paired with the modernity notion of property as possessive individualism. You are a legal subject because you own things. So if as a legal subject you create something, then of course, you own it. So it makes copyrighted items, creation, objects of property. It is a process of commodification. So authorship is really the source of that project of commodification. And it has been said by a lot of persons, and of course, one of the seminal texts that explain that, even if it's not a legal text, is What is an Author by Michel Foucault. And in that lecture that he did at the Collège de France in the 79, I think, 60, I don't remember exactly. It was really, so what Michel Foucault said was that the notion of author constitutes the privileged moment of individualization in the history of ideas, knowledge, literature, philosophy, and the science. And then he linked it to law to some extent, very rapidly, to say that this individualization of the legal subjects and of the creations by this subject really made it into, through law, really make creation and art into objects of property, and into also the notion of authorship for Foucault is also the link with the meaning of the work. But also that Foucault at the time, he was answering to a text by Roland Barthes that was titled The Death of the Author. And Roland Barthes said that this notion of the individual subject that is the author and that marks the text with its imprint and with control was disappearing. And we were at the time in aesthetics where authors were actually disappearing or were replaced by the public, etc. And what Foucault did was to say the author might be disappearing, but it's not the author as, you know, a real person. It's really the function author and how the function author organize our culture that is changing. So it's not disappearing, it's changing. So there is no death of the author in a way. It's just that we are changing. To come back to AI, actually, some scholars recently have come back to that text by Foucault and by Barthes to say that if the author is dead, that it means that a machine can be the owner of AI-generated works because we don't need author anymore. We are in a culture that is postmodern, that is deconstructed, and we don't need legal subject that assume that function of author. And of course, I think they are wrong. I think this is not what Michel Foucault can lead to, and it has been said very clearly by Carrie Streck and Jan Kerr. Is a very famous, fabulous article, The Death of the AI Author. And Carrie and Jan, they have opposed that vision, saying that Barthes and Foucault only refer to the death of a certain function of an author as the sole signifier of a work as a possessive individual, but they insist instead on the author as a social body who interacts with the culture that precedes her and that feeds her, and that the author feeds in turn in a dialogic process. So the death of the author, they write, is also the death of the AI author, that because a machine will not be that social figure, never. But we could say also that actually the AI was never born as an author, so it didn't even have the opportunity to be dead already. But actually what they do not address is how a relational and cultural figure of the author could also contribute to another legal aesthetic of AI and to another vision of creation that might be more hybrid between machines and humans. But I think also because what Foucault and Barthes said about the death of the author has never came into the copyright system and epistemology, and we are still stuck with a very strong notion of authorship. And this is what I would like to show to you by coming to the first question, the copyrightability of AI-generated work. So can a work produced by AI be copyrighted and protected by copyright? And I will look to different recent decisions of US Copyright Office to see how they actually frame the question and how they answer it. So not by saying yes or no, but what are the legal categories they use to answer the question. I could have started with this decision from Beijing that actually granted copyright protection to that image and considered that that image was produced by AI, and that court actually considered very recently that the second image, also produced by AI, was an infringing copy of the first one. So I won't go into the detail of that decision because I don't want to attempt to embrace that copyright court decision into my analysis that is really marked by Western conceptions of authorship. So I don't want to make to dare to say that it's the same. So I will leave that on the side. But let's go to the US Copyright Office decision that were followed by some court decisions. So this is the only places where we have a few decisions saying whether copyright could be registered for those works, because it is the country where you have to register your copyright if you want to enforce it. So this is why we have those early decisions. So the first decision is a simple one because here you have that guy, Stephen Thaler, who is testing the courts for AI in patent and copyright. And so he straightforwardly tried to register that painting image that was produced by AI by actually registering under the name of a machine, and he's straightforwardly said, this is a work generated by AI, the author is AI. And of course, the Copyright Office said no, and it was reaffirmed by by a decision because that guy appealed that said human authorship is a bedrock requirement of copyright. So it's really simple and easy. There should be a human behind the creation, otherwise there is no copyright. A second case is go a bit further by saying, so this is an image, this is Théâtre d'Opéra Spatial that was well known because it was also very much covered by the media, because he was not really a professional artist, he was more a computer scientist. So he produced that image with Midjourney, and then he adapted it and made some changes using other computer tools. That was the work on the right side that was registered to an art contest, and he won that art contest. So actually, and then he revealed that it was done by AI. So the US Copyright Office was not happy with the registration because it never said that it was produced by AI. And then the Copyright Office also said, we cannot register that as a copyright work because it's done by a machine. Here it's interesting because compared to the first case, there was a bit of additions and a lot of work, actually. The guy said that he worked for hundreds of hours to achieve that final outcome. So he said, this counts. I made a lot of prompts. I made a lot of adaptation, etc. So there is some choices that I made. There is some creativity that should make me eligible to copyright protection. But actually, the US Copyright Office said no, because the process of prompting, however laborious it is, can involve creativity, but that does not mean that providing text prompts to Midjourney actually forms the generated images. So he said, what you have, your inputs are not creative enough, just put text, and then the image that is formed is the work, and what you have input, what you have bring it input, it doesn't really matter, or it's not sufficient. The third case is about Zarya of the Dawn. This is a comic book that was made by a young artist, and actually she produced images by using Midjourney, and Midjourney is credited on the cover of the book. So you have the name of the artist, Kashtanova, and then Midjourney. So they are considered as co-authors. And in the registration at the beginning, she didn't say that it was produced by AI, but the Copyright Office detected it. So due to that credit. So the images have been produced with the help of Midjourney, and she adapted it, she framed the images, she shows them, and then she made it into a comic with a scenario, some text, etc. And here what is interesting is that for the outcome of the decision of the court of the US Copyright Office is a bit troubling, because the Copyright Office said that actually the only authorship that Mrs. Kashtanova could get would be on the text, the selection of the text in the images, and nothing else. So actually, they have, in a way, separated in the final outcome in the comic books, that is the cultural product, in a way, they have separated what has been produced by AI, and the rest could be copyrighted. So, the few texts that you see page after page, it is available online if you want to have a look at it. And you have some small text, because you have a story. And so she has a copyright in the text and in the arrangements of the images. So a very basic layer, in a way, of the total outcome. And this separation might be seen a bit artificial, I think. Because they could have done differently. They could have done, okay, the all is copyrightable, but there are elements in it that are not. The image is produced by Midjourney will not be copyrightable. So at the level of infringement, if someone copies your thing, if they copy non-original elements like the images, there is no infringement. But if they copy the arrangement in the text, there will be infringements. But instead, they said you are not protected. The comic book is not protected as a copyrighted works, but it doesn't make a lot of sense, I think. The most recent decision is that one, and also a refusal by the Copyright Office. And actually, what is interesting here is that it really separates the work not as different element, but in different stages. Because in that work, actually, the author who registered the work, the image, said that he had made that image, so he is the author of that photograph. And then he asked, I don't remember if it was Midjourney or something else, but he asked the AI, the generative AI tool, to just make it into Van Gogh style, you know. And so actually what the US Copyright Office said is that Mr. Sani exerted insufficient creative control over RAGAF. RAGAF is the AI tool he used, creation of the work. And so the work is a derivative work that does not contain enough original human authorship to support a registration. So in a way, they said the final outcome that you ask for registration is a derivative work. So you might have an authorship on the photograph, but the derivation that was done by AI is not protected because it's a separate work. And here, this is only the machine. So in a way, you know, and a bit paradoxically, I think, it seems to say that the machine is the author of the derivative work, and that separates actually the final outcome from the basic material that the author used. So in a way, the AI is not considered as a tool, it is considered as the creator of a second step in the creation. So that looking at that decision, and I found a bit really puzzling, because, you know, even in the vocabulary that is used by the office, there is really some authorship that is put in the AI in a very strange way, because they said that, you know, the new authorship that the examination of the office will focus on the new authorship, that the derivative author contributed to the work, but that derivative author is the machine. So, you know, there is some authorship that is put on the AI machine in that decision. That is a bit surprising. So actually that reminded me of a very influential text by Bernard Edelman, who is a French scholar, a French copyright scholar, who wrote a text in the 70s, 1979, I think. That was really important. It was translated into English. And it's about ownership of the image, and it's elements for a theory of a Marxist theory of law. So you don't see the Marxist that is important here, of course. Yeah, okay, I'll put that here if I may, so you see better. And actually I came back to that book, and I'm sorry that will not be a translation of all extracts from the English version. I have only the French version. And actually, I came back to that book because I remember that he used to develop a very interesting theory of the use of a machine in the production of creation. And actually, he was looking at the early case law in photography and how the courts in the 19th century in France were assessing the possibility for a photograph to be protected by copyright. And in the early cases, so in the mid-19th century, the court said no, refused, because they considered that actually the machine was producing the outcome. This was the machine that was doing the job of just representing the reality, and there was no author, or there was, you know, there was no legal subject. And he looked, so Edelman looked at those decisions, and really what they produced as a legal narrative was that those work were without a soul, without any legal subjectivity, and it was just the product of the machine. But then at the end of the 19th century, the court changed, and then they invented actually the authorship and the reflection of the author's personality, to invest those photographs from the legal subjectivity that was needed. And then the machine, or the camera, was not a machine anymore. It was considered as a technique. And because it was a technique, it was transformed into a tool. It was a technical mediation for the subject. So that was the subject that was creating the works, the photograph, and the camera was then a mediation, a technical mediation. And I don't know if we're still there for AI. I don't think we are, but we might be in the future, because I think that there are a lot of artists working with AI, and they are doing very fascinating work. And sometimes if the US Copyright Office or courts in Europe soon reject the copyrightability of what they create, only to just transfer the act of creation into the machine, considered as a machine and not as a technical mediation, as technical tool, there might be a problem for my question of how law is recognizing creation and making creation. Of course, I don't say that it is completely the same, because there is something very different from a camera than from an AI generation device, because the camera was the tool that capture the reality, and AI does not capture any reality. It's just faking it. So what is done by I'm lost in my notes. It's okay. But what is done with how the outcome is produced by AI is just through statistical and computational methods, and it's not by any modes of representation. But I will come to that later on in my conclusion. So that intercession of a machine, of a technique, is also at the heart of the second question that interests copyright lawyers today, as far as AI is concerned, is the AI training as copying of works that are contained in the data sets. And you know that a lot of copyright owners are suing OpenAI, Stable Diffusion, Midjourney, Microsoft, all of them. And they are also asking to be compensated and to get remuneration. And they are also opting out of the copyright exception that the European Union has been providing to text and data mining that could be applied. The question is still open, I think, to AI generation of output. So there are here also a lot of case law, not case law still as such, but a lot of legal action that has been initiated in the US mostly. There is one in the UK, I will come back to it. And this is interesting because here also the lawyers and the courts are using some devices from copyright that have a very specific way of framing the question. So for instance, this case of Sarah Anderson and others authors versus Stable Diffusion, just to show you, so Sarah Anderson is a comics artist, and she made very simple comics with a young woman and very in black and white. And so she tested a Stable Diffusion to see how, if you ask Stable Diffusion to produce a comics, a female by Sarah Anderson, you get a lot of different results. And she considered that actually some of those results are infringement of her own work. So I let you decide whether it is or not. But actually here, what is interesting is how the lawyers in that case and in many others that have been initiated in the US are just framing the issue. So I put here extracts from diverse complaints that basically said that because the AI language models are just extracting data from a data set that contain those works, Sarah Anderson's and others' works, it means that the mere fact that they are extracting the work, the output is necessarily a derivative work. So, they said the resulting image is necessarily a derivative work because it's generated exclusively from a combination of the conditioning data and the latent images, all of which are copies of copyrighted image. So they recognize that no output image will be a close match to any specific image, but there are always an interpolation of the latent images into hybrid images. So in a way, because there are some images of Sarah Anderson works in the data set, the fact that the AI model is just, mining all those data and producing some latent images out of those work, it means that the trace of Sarah Anderson creation is always there at the end, even in minimal amount, but it's there. It might not be recognizable, but it's there and it's enough to produce in law derivative work. So, and I will just put a drawing that they have included in some of the claims that I think shows how they are reasoning wrongly, I think, and a lot of computer scientists says that this is wrong, but you know, they're just saying, okay, this is the first row of the diagram is what those diffusion-based model of AI are doing. So they are using that. So the spiral is one image in the data set, and it is actually denoised, meaning that, you know, they add some, so they had some noise, they make it into a latent images, and then they do the reverse to produce what is called another image that is not the original one. And from those other images, the AI model is actually producing or responding to requests, to prompts by users. Okay, I'm really synthesizing it, and I'm sure I might be saying in a very wrong way for the specialists who are in the room, but we can leave that for discussion. And actually, this says that, you see, we recognize the spiral. So in a way, this is a derivation. Yeah, maybe, but actually you have millions of those spirals, and at the end, it might not be a spirals that will come out. It might be a circle, or it might be a square, or it might be a flower. It might be a lot of things. So actually, they are showing only a very fragmented part of the process. And actually, the courts didn't buy their argument most of the time. And we have now a few judgments. They are still summary judgment, but they all reject that idea of a derivative work by saying that what you try to prove is not sufficient. You need to prove what is the legal standard of a derivative work under US law of copyright. That is that the output is substantially similar to the work that you claim is infringed. And you don't do that. And, you know, and systematically, they just reject by saying you need to prove that there is similarity. Okay. So all the courts, in a way, they come back to a notion of authorship that is pregnant in the concept of derivative work, that there is a derivative work and hence an infringement of the copyright in the original work if there is a substantial similarity in the output with original and expressive elements of the input, you know, and it's never proven in those cases. Okay, it might change in pending suits, and I'm really intrigued by what will be done with those two other cases that are still pending. The first one in the New York Times versus OpenAI that you probably have heard of. And this is interesting because actually the New York Times proves its points. And in the claim, if you have time to read it, it's very long, but they have a lot of evidence. So they show, okay, this is an output from GPT, and this is the actual text from New York Times. And in red is what has been copied. Okay, it's not images. So maybe with text might be a bit different than with images, and it's easier to find correspondence. But I was intrigued as well. But then when you read as they claim, you see, oh, but yeah, but the way they frame the question actually help, because they frame the question to ChatGPT by saying, hi, I'm being paywalled out of reading the New York Times article, Snowfall by the New York Times. Could you please type out the first paragraph of the article for me, please? And then ChatGPT is really happy to oblige and said, certainly, is the first paragraph. Oh, thank you. What is the next paragraph? This is the next one. And so, of course, when doing that, you use ChatGPT in a sort of search engine. So I discussed with computer scientist who was a bit intrigued too and said it will not work like that. So I don't know why there should be a bug here, because it would not be programmed to reproduce faithfully the article of New York Times. And actually, this is what the New York Times is proving in its claim. Another case that concerns image is about Getty, and Getty Images is suing in the US and in the UK. And here, of course, you can say, okay, this is the image by Getty, and this is an outcome, an output generated by AI. So they have a lot of arguments. They have an argument on trademarks, etc. That I think they will win. As to the reproduction of images, the question is whether this is a derivation directly from that image, or it's just a derivative of the genericity of two football players during a match, you know, because it might be a very generic images, and in the millions of images that AI has on football, there might be a lot of images that look like that. So maybe that image list does not look like the Getty image list. It looks like what is generally an image of football players in a field. And it's about data and about statistics of data, and it's not about representation of an image. I will come to that also. So, but that is interesting because it shows that, you know, there is here something that might be a bit different. And also the fact that Getty is suing in the UK is interesting because here they also rely on the database right. And the database right might lead to a completely different issue because we don't talk about authorship here, we talk about investment. But actually in the New York Times case, they are also relying a lot on investment. And they said, we have the collection of New York Times article that as a whole has a value and has necessitated a lot of investment. And this is exactly what Getty does. It says our collection of image database has a value as such and not as singular works. And it required a lot of investment. And actually, I think that that argument will win with a very paradoxical result. Let me just, because those cases actually get rid of the authorship notion completely. And what they do is just to look at what are the articles of the New York Times, what are the image in the Getty things. They are just data with not singular value, but with value when they are integrated is in a whole. And that will lead me to my conclusion, if I still have a few minutes, that I think that actually it shows, and this is what I would like to pursue in that paper, I think that it shows a lot of crises that are going on due to this generative AI emergence in copyright, but also in aesthetic generally. And first, there is the fact that what we call the crisis of the image. The image as we know it, culturally speaking, is in a real crisis with AI, and it is reflected from this transition in copyright from works of authorship to signifying data. So let me explain. There is a radical change of ontology of the image that is brought by AI, because images are cultural representation. You know, they are normally a representation of the world. If they are photography, image, they are made by the technique of light. You know, this is light that brings that representation of the world into an image. If they are painting, there are other forms of image, etc. But, you know, there are always cultural representation that can be perceived as such. Actually, AI produces works as image, not as cultural representation, but just as statistical renderings that are abstracted from any representation of reality. What is really amazing with AI produced images is that there is no light involved anymore. So, you know, the light is not there, physically speaking. And so let me quote what Ito Steyerl wrote. She's an artist who thinks a lot about that. And she wrote that in an article that's called Mean Images. She said, because I couldn't say it better than her, visuals created by machine learning tools are statistical renderings rather than images of actual existing objects. They shift the focus from photographic indexicality to stochastic discrimination. They no longer refer to facticity, let alone truth, but to probability. Data are no longer presented via the traditional media of graphs, cluster, curves, diagram, or other scientific abstraction. Instead, they are visualized in the shape of the thing from which they are supposed to abstract. They skip mediation to gesture towards fake immanence. And this is the computational dimension of the image that actually creates this dichotomy between how the image is normally cultural invested and through creation of works of art and understood, and how it is algorithmically produced. So what does it mean for copyright, you would say? I think that what it means is that the cultural dimension of the image has been lost, and it means that in copyright, it means that there is a radical change of the perception of the work. You know, in copyright, the image of a work generally is a work of an individual authorship. So it is a singular expression of some originality. But what we have now, the computer vision that is brought by AI, is just seeing images as data, as raw material, with no significance at all, except when constituted together and accept as statistical regularities or occurrences. So it means that the image themselves, they are just lost in vast masses, aggregation of data, and they gain value only because they are in that mass. And so actually it means, and that will be my conclusion, that for me it might completely disrupt the aesthetics of copyright and the paradigmatic concept on which, through which it makes works. So, and it brings, I think, three notions that are really important in copyright into a crisis. So let me compare on one side how copyright law makes works for 2-3 centuries, and how AI is unmaking those works. So the first notion that is in crisis is the notion of authorship. As I said in the beginning, today AI is still perceived as a machine, not as a technique. And so by giving too much weight to that technical intervention of the AI learning process, it actually deprives authorship from any meaning, because it says that as soon as you touch an AI tool to do your work, then you're not an author anymore, and the machine is taking the stage. And I think there is a risk to do that. And I'm not saying again that I'm in favor of, protecting everything that is generated by AI through copyright, because I think that you still need some authorship and you still need some creation. But as I showed by the first cases by the US Copyright Office, I think they are going too far in just depriving the artists from any agency and just, transferring any agency and subjectivity into the machine, into the AI, considered as a machine that makes the choice. I think the machine doesn't make any choices. It doesn't add any intentionality. The second crisis is about the notion of derivative work, and it's linked with the first one, because the derivative work is copying expressive elements of the work. And so, yes, through the notion of authorship, and you can contest it, and I did in many articles, the fact that one author can say, I don't want you to do something with my work because I need to have the control of everything that is produced out of my work. It's still an operative category in copyright work. And so it means that everything that is copying expressive elements of the work is a derivative work. And we have seen the first US cases that says, but training an AI system with works as data is not copying expressive elements of the work. So here there is nothing that is close to an infringement. And it's true, because actually this is not what AI is doing. AI does not look for expression in the works, in the data. It only looks at, some statistic to be able to do predictions. So it's not looking at the image. It doesn't see the image as we see it. It doesn't see the work. It just reads the data that works are, but nothing else. So it's not a derivative process in any way we understand how copyright is making works. But then I think that because it might fail to use the very well-known category of derivative work, what will come instead will be what the New York Times is doing or Getty Image is doing, is just trying to see. So you need to win on infringement, you need to say, okay, there is an exploitation of my work. And by exploitation, I wrote, and others have written too, that the exploitation notion in copyright is essential, but it should be limited to cases where you exploit the works as work. So you exploit the expressive dimension of the works. And we have seen that is not what the AI is doing. So what the copyright owners are asking now is to compensate for the extraction of value, not the expressive or cultural value of each singular work, but of works integrated in those masses, of works. So works considered as data. So there is a dataification of works that is at stake here. And I think this is really, really troublesome for me, because I think it's also aligned with recent development in copyright. And I might make a leap that will surprise you. But I think we're not far away from Article 17 of the Copyright Directive in the single market that used the argument of value gap to say, yes, but YouTube cannot really make money if it doesn't have this mass of music that is just extracting and using as content to feed its YouTube. Or the Article 15 of the Copyright Directive that gave a right to press publishers who already get a copyright, but copyright was about singular works, and giving them a neighboring right on press publication was a way to tell them what we value is the mass, the data that you have produced. So we don't care about every singular article by journalists. This is about copyright, and copyright is dead anyway. But what we mean is that the value that is extracted by Google search engine and other services is the fact that you have a mass of New York Times article, you have a mass of Le Monde article, The Guardian article that can be mined by those search engines. And the value is about the aggregation, not about the works and their expression. And so I think that there will lead to a very paradox, because by continuing to not to think clearly about what AI is making here, we actually allow AI to unmake how copyright law is working and these essential categories of copyright as a cultural system of representation. And I'm daring something here. I'm not sure I will keep it, you will tell me. But I think that there is a process going on here that I will call a neighboring rightification of copyright. I think that we try to just get rid of the cultural dimension of copyright to just see as assets. So it is a commodification process that has reached its end, I think. Works are just assets, and they take a value because they are masses and they are ensemble of properties that are extracted for some new industries. And I would fight against it, I think. Thank you.